Hello, good morning to you. Welcome. It's Andy here and talking ready with the new logo. It's quite surprising how much I used that logo everywhere and trying to find them all and change them over. I'm sure there'll be one or two that I missed somewhere. But yeah, and so we're talking about the DWP today. The fact that they can just automatically take our money out your account to pay bills, and this is one of the things that I'm very, very annoyed about, because at the moment the HMRC have not bothered for about 9 years, and now all of a sudden they say, oh, you owe some money, we want it back, we're going to contact the DWP. Well, I've obviously put in my complaint about that. And I found this piece of legislation. It's a case law thing. It was done, when was it? 2022. I'm going to show you in a moment, but the idea of this is that somebody went to court about it because they just took money. It could be for benefit deductions, it could be for bills like electric or gas or whatever. And this is talking about third-party bills, not benefit overpayments or anything like that, where they've paid you too much, they can take it back. This is actually paying third parties. So, for example, you may owe something to somebody, and they contact the DWP and say, we want our money back, and then they pay it. Well, what they're saying is that this went to court and it was determined unlawful, because the implication is that they are taking the word. They're taking the word of whoever it says. So I could go to the DWP and say, Fred Bloggs owes me money, I want it back. And they'll give it me. And of course they're saying, well, hang on, do they even know that there's a real case there? Do they know there's a real debt? Have they asked the client? No. Anyway, so this is the story. The High Court has declared unlawful. This is the third-party deductions. Obviously, making direct payment to utility companies in particular. He dismissed the claim that the guidance infringed Miss Simpson's rights under the European Convention for Human Rights, ECHR. Remember that one, because that's very important, because the government want to get rid of it, yeah? So, and people moan about it, oh, we've got to get rid of that. No, it protects a lot of things. Anyway, the ruling means that the guidance must be altered and make it clear that the DWP, the claimants, should be given the opportunity to make representations, i.e. they should be allowed to say it's not real, it's not allowed, it's not actually a debt, and obviously then provide evidence of that. It said the previous guidance did not stipulate, and so obviously the claimants could not easily dispute whether the money was owed or not, and they just paid it. So you see, this is a judgment from 2022. Good news, if you have a debt and you're paying it and you don't agree with it and it's not right and you don't actually owe it, then basically you can tell them to steal up your ass. And you can actually argue the case that you don't owe it. If you don't owe it, then give them evidence of that, and then, hey presto, hunky-dory, you're basically not going to pay the money out to any third parties by DWP. Now, whether that will work for me, I don't know, because it is a HMRC, and it is technically, it's a benefits type payment, so there is a law around that they said that they can just take it back. The thing is, they wouldn't have done it if I wasn't on UC. So UC is where the floor is, because they can just do it with the UC. You have no choice. They will just do it. And if it wasn't on that, if I was just on normal, then I can argue that and say, well, no. But of course the law is very specific about the UC payments. Right, that's the story. Let me know if it's any use to you, or if you've been affected by it, then let me know. Have a good day. See you soon. Bye for now.